Hello, dear friends. In the first lecture on Erasmus Ecclesiastical Law, I tried to give you the three pillars of the object of the so-called ecclesiastical law, and I said that the term ecclesiastical law does not correspond to its content or object of today, because it is this name ecclesiastical law is an old one. Now, in this second lecture, I will analyze the general comment number 22 of the Human Rights Committee on Religious Freedom. Then, in the following lectures, from third and so on, I will enter into relations between church and states. In the beginning, church and state in modern Europe in general, a general presentation, and then I will enter into church and state relations in the European countries with predominantly Orthodox population in majority. Now enter in the analysis of the General Comment number 22 of the Human Rights Committee of the United Nations on the Article 18 on religious freedom, because it contains an authoritative interpretation of international religious human rights standards. Paragraph 1. The right to freedom of thought, conscience, or religion, which includes the freedom to hold beliefs. In Article 18, Paragraph 1 of the International Covenant on Civil and Political Rights is far-reaching and profound. It encompasses freedom of thoughts on all matters, personal conviction, and the commitment to religion or belief, whether manifested individually or in community with others. The committee draws the attention of state parties to the fact that the freedom of thought and the freedom of conscience are protected equally with the freedom of religion and belief. The fundamental character of these freedoms is also reflected in the fact that this provision cannot be derogated even in time of public emergency, as stated in the Article 4, Paragraph 2 of the International Covenant on Civil and Political Rights. What does the Paragraph 1 of the General Comment number 22 say? It says that the right to freedom of thought, conscience, and religion is not only one right, it is a group of rights. And this group of rights, which is called freedom of thought, conscience, and religion, or religious freedom, is subdivided into two subgroups. The first subgroup is named as freedom of religious conscience. When we speak about religious, we mean also non-religious. And this subgroup, it contains also many religious human rights. The other subgroup is named as religious manifestation, religious or non-religious manifestation. And also it contains a lot of religious rights. But when we see the phrase freedom of thought, conscience, religion, we understand that we have three rights: freedom of thought, freedom of conscience, freedom of religion. But this is not true, because each of these rights is a general one, because it contains a lot of partial conscientious or religious rights. Paragraph 2nd. Article 18 protects theistic, non-theistic and atheistic beliefs, as well as the right not to profess any religion or belief. The terms belief and religion are to be broadly construed. Article 18 is not limited in its application to traditional religions or to religions and beliefs with institutional characteristics or practices analogous to those of traditional religions. The committee therefore views with concern any tendency to discriminate against any religion or belief for any reason, including the fact that they are newly established or present religious minorities that may be the subject of hostility by a predominant religious community. What does the paragraph 2nd of the General Comment 22 says? It speaks about the beliefs protected. The beliefs protected can be theistic, non-theistic, or theistic. And this belief, theistic, non-theistic, or atheistic, one, do not belong only to religions, because, of course, they belong to religions, as religions can be theistic, non-theistic, or atheistic. One. Buddhism, for example, is a non-theistic religion, and the school Theravada of Buddhism is an atheistic religion. And the non-religious beliefs are protected for people who do not profess any religion or belief, or for the communities of non-believers. The terms belief and religion are to be broadly construed. the legal meaning of religion and of course of belief is difficult to be defined. In Europe, for example, there is a very small elaboration of this legal definition of religion. But in the United States, either in legal theory or in case law, there is a very broad, very large elaboration of these terms, especially in terms of religion. So in the United States, three types of legal definition of religion have been formulated. First type of legal definition of religion is an objective one. That is, a definition which has a group of elements. For example, what is religion? Religion is the belief in God. This is an objective definition. And because not all the religions have a belief in God, this definition is not in conformity with religious equality. So, another type, another group of legal definitions of religion have been evolved. The subjective one. Subjective definitions of religion correspond to the value which a belief has for the individual conscience of a man. That is, what is the value of a belief for individual which is similar to the value which is valid as it concerns objective definitions of religion for the followers of the religions which can be incorporated to this type objective definitions of religion. For example, an athletic ideal can assume a value for an individual which is similar for a follower of a god according to a religion which has a belief in God. An actor also can assume such a value for the individual conscience which a God has for the conscience or a follower of a religion which has a belief in God. For example, there is a religion of the followers of Elvis Presley, which was a famous American singer. There is also another type or group of legal definitions of religion which are called analogical one, and which could be in conformity with religious equality than the other two types or the other two groups of legal definitions of religions, that is, the objective or subjective one. As it concerns this group or type of legal definition of religion, the analogical one, two lists of characteristics have to be elaborated. One list of characteristics of the already known religions has to be prepared. And also another one list of the characteristics of a group which supports that it is a religious one and which wants to be recognized as a religion for the aims of a state law. I have to note that legal definitions of religions are not required, must not required for the enjoyment of the human rights, religious human rights, because to enjoy religious human rights for a group, it is enough for it to say that it is a religious one. And it has not to prove that it's really a religious one. A legal definition of religion would be necessary if a state confers religious privileges to religions. Religious privileges are religious rights given to religions by states, and which religious rights are beyond religious human rights recognized by the international law or constitutional law. For example, religious assistance in the army, religious education in public schools, tax exemptions, recognition of religious marriages as valid legal form of marriage according to state law, etc. But the two lists to which I have done already reference. That is the list of characteristics of the already known religions, and the list of the characteristics of a group which wants to be recognized as a religion for the aims, for the purposes of a state law. For example, for the purposes of a tax exemption law. You have to be compared and the list of the characteristics of the already known religion must be in conformity with religious equality. That is, it must not discriminate against any religion when it is prepared, when it is elaborated. From the comparison of the two lists, someone can conclude that the characteristics of the most characteristics of a group which supports that it is a religious one and which it wants to be considered as a religion for the purposes of a state law coincide with the characteristics, with most characteristics of the other list, which contain the characteristics of the already known religions. So from this exposition of the different types or groups of legal definitions of religion in the United States, it's clear that the elaboration of a legal definition of religion is not an easy work. For that reason, the second paragraph of the General Comment number 22 does not give any legal definition of religion, and it says only that the term belief and religion are to be broadly construed. And religious liberty is not limited to traditional religions or to religions and beliefs with institutional characteristics or practices analogous to those of traditional religions. The term religion concerns also the new established religions. They are known for a society, religions. The religions which have not institutional characteristics hold by the known religions. Now we go to the paragraph 3 of General Comment number 22. Article 18 distinguishes the freedom of thought, conscience, religion or belief from the freedom to manifest religion or belief. It does not permit any limitation whatsoever on the freedom of thought and conscience or on the freedom to have or to adopt a religion or belief of one's choice. These freedoms are protected unconditionally as is the right of everyone to hold opinions without interference, Article 19, paragraph 1. In accordance with Article 18, paragraph 2 and 17, no one can be compelled to reveal his thoughts or adherence to a religion or belief. In the Article 3, there is a further explanation that religious freedom as a group of rights is composed of two subgroups, one subgroup under the name freedom of conscience, religious or non-religious, and the other subgroup of rights, freedom of manifestation of religion or belief. And the religious rights of the first subgroup cannot be limited, they are unlimited. The religious rights of the other subgroup, under the name freedom of manifestation of religion or belief, can be limited as it is clarified in the next paragraphs of the general comment number 22. The paragraph 3 also says that the right to have a religion or belief is a religious right belonging to the first subgroup, and the other religious right to adopt a religion or change religion is another religious right belonging to the first subgroup under the name freedom of conscience, religious or non-religious one. In the paragraph 4 of the General Comment number 22, we read the freedom to manifest original belief may be exercised either individually or in community with others and in public or private. The freedom to manifest religion or belief in worship, observance, practice, and teaching encompasses a broad range of facts. The concept of worship extends to ritual and ceremonial acts, giving direct expression to belief as well as various practices integral to such acts, including the building of places of worship, the use of ritual formulae and objects, the display of symbols and the observance of holidays and days of rest. The observance and practice of religion or belief may include not only ceremonial acts, but also such customs as the observance of dietary regulations, the wearing of distinctive clothing and head coverings, participation in rituals associated with certain stages of life, and the use of a particular language customarily spoken by a group. In addition, the practice and teaching of religion or belief includes acts integral to the conduct by religious groups of their basic affairs, such as inter alia, the freedom to choose their religious leaders, priests and teachers, the freedom to establish seminaries or religious schools, and the freedom to prepare and distribute religious texts or publications. We see that the paragraph 4 of the General Comment number 22 refers to the substantial contents of religious or non-religious manifestation. But time is over. As concerns the present lecture, So we'll continue the explanation of General Comment number 22 in the next third lecture. Dear friends, thank you for your attention.